Hello and welcome to Myotherapy ConneX. It's great to have you join us today for our free webinar series. I'm your host, Erin Baker, and today we're talking about complaints. So this is something that I know many of us cringe a little bit on the inside and probably prefer not to think too much about. But while it is our responsibility to comply with Australian laws and professional codes, it's important to remember that as a practitioner who strives to provide high-quality, person-centred care, our patients must feel empowered to speak up when something's not working for them, particularly in their healthcare service. And this really goes to the heart of patients feeling valued, respected, and supported, and essentially what it means to be a patient-centred practitioner. So let's dive into our discussion today. As a self-regulated profession, we voluntarily choose to join a professional association body and agree to abide by the association rules and codes of conduct. In addition to this, we're also subject to a range of laws that regulate our practice, including the National Code of Conduct for Healthcare Workers, laws around the use of therapeutic goods, consumer protection laws, and health complaint laws. For many of us, we probably don't think too much about these specific requirements on a day-to-day basis. For lots of us, once we sign our association's agreement and we agree to abide by the code of conduct, we put our practice policies and procedures in place, then we just turn our focus to being the best practitioners that we can be. But while we may not always like to think about it, complaints are something that can arise. Complaints may be made directly to you or your workplace. They may be made to your professional association, or they may be made to your state's health ombudsman or commissioner. Having a complaint made against you as a practitioner can be stressful, no matter how big or small that complaint is. And one of the reasons that it can be stressful is because many of us are simply not sure what it means when a complaint is made, particularly when it's made to your state's ombudsman. Who has the complaint gone to? What will happen next? What should you do in response? So one of the ways that some of this stress can be relieved is by being informed about the roles, the processes, and the powers of the Health Complaints Commissioner or Ombudsman. So today, I'm joined by Imogen from the Health Complaints Commissioner Victoria. The HCC are the independent and impartial body responsible for handling healthcare complaints. Imogen's here to talk to us about the Health Complaints Commissioner's investigative powers, the complaint resolution process, and how you as a practitioner can take steps to help avoid complaints arising. Imogen is the current Manager of Investigations and Compliance at the HCC and has been working for them for just over 4 years. Prior to that, she worked at the Australian Health Practitioner Regulation Agency and has worked for various other healthcare regulators in the UK. So welcome, Imogen, and thank you for joining me today.
Thank you for having me, Erin, and thank you for inviting me to speak to you and your members. So I'll kick off now. As Erin said, I'm Imogen, and I'm the Manager of Investigations and Compliance at the Health Complaints Commissioner here in Victoria. So in today's session, I thought it would be good to give you a little bit of an overview about who our Commissioner is, an overview of the Health Complaints Act, an overview of what we do here at the HCC, your obligations under the Code of Conduct, an overview of our investigations and powers, an overview of findings and recommendations that we can make once we finalise an investigation, and sanctions as well. And I'll give some stats from our last annual report about the complaints that were actually made to our office. And Erin's also posed some questions to me, which I'll answer towards the end. So who's our Commissioner? Our Commissioner is Adjunct Professor Bernice Redley. So she commenced on 1 July this year. She's a highly respected health academic with leadership experience across university, health service, and government sectors. She comes to us from the School of Nursing and Midwifery at Deakin University, and she's also a registered nurse. So the Health Complaints Act, the Act commenced on the 1st of February 2017, and that created the Health Complaints Commissioner. So we took over from its predecessor, the Health Services Commissioner. The key concepts of the Act is that it applies to all health service providers in Victoria. So that's both registered health practitioners, which are regulated by UP, and also what we call general health service providers. It created the definition of a health service, which is a very broad definition, but in summary, it's an activity intended or claimed to assess, predict, maintain, or improve the physical, mental, or psychological health or status. It also created the definition of general health service providers. So that's anyone in Victoria that provides a health service that is not a health profession service. So a health profession service is those registered health practitioners that are regulated by AHPRA. Some examples of a general health service provider, and this is not an exhaustive list, is myotherapists, massage therapists, naturopaths, counsellors, social workers, sonographers, and we also deal with people who provide illegal cosmetic injectables and other people who make claims to cure cancer and other serious illnesses. So it introduced the complaint handling standards and the code, and it set out the complaint handling and investigation frameworks. It also increased our powers and gave us the ability to conduct investigations, issue or execute search warrants, conduct investigation hearings, and issue sanctions. And it also gave us greater information sharing powers with other agencies. So in the Act, we have the health service principles and we have the complaint handling standards. So they apply to all health service providers, both registered and general health service providers. The code and any sanctions that the Commissioner may make, they only apply to general health service providers. So what do? We help consumers resolve complaints about health service providers and the handling of health information in Victoria. We provide an accessible and free alternative to legal proceedings. The majority of the complaints received by our office are actually dealt with in complaint resolution, and we can obtain potentially a refund, compensation, apology, or explanation. We also administer the Health Records Act. We are a regulator of general health service providers in Victoria, and we can help protect the public from serious risks. As I said before, we've got the ability to conduct investigations and issue orders or general health warning statements when it's appropriate to do so. So this is just a little snapshot which is taken from our website about the process. So once a complaint is lodged with the HCC, it goes into an intake and assessment team where they assess the complaint. At that point, we can either refer it to another agency if we think that another agency is more appropriate to deal with it, or we can decline to deal with it if we don't think that we should be. If we do decide to deal with the matter, there's three avenues that the complaint can go down. So that's early resolution, formal resolution or complex resolution, and investigation. So I'll just give a brief overview. Resolutions is not my area of expertise, so I'll just give a brief overview of what they do there. So as I said, initially, the complaint will be assessed. So what we're going to be looking at is it in our jurisdiction? Can we actually deal with the complaint in the first place? We look at whether or not we need to notify UP. So if we do receive a complaint about a registered health practitioner, we have an obligation to tell AHPRA about that, and both of us have to seek an agreement about who's going to deal with it. We assess whether it relates to a breach of the code. So if it does, generally investigations will be notified about it, and then we will decide whether or not we need to conduct any preliminary inquiries into that complaint. Most of the time, we will ask the complainant whether or not they've attempted direct resolution. So that means whether or not they've come to you as a provider and tried to resolve the complaint themselves. Most of the time, if they haven't done that, we will ask them to go back and do that. But in some instances, it's not appropriate for them to do so So, for example, if there's an allegation of sexual misconduct, then it's not appropriate for them to resolve that and it will come straight to investigation. And as I said before, we'll also assess whether perhaps another agency is more suitable to deal with it. So if we decide to deal with the complaint, it can go into early resolution. So this is the least formal way for us to be able to deal with a complaint, and it's often the most quickest. So that might be the resolution officer giving the complainant a call, giving you as the provider a call, and trying to clarify the problem and trying to seek a solution. So some of the possible outcomes might be the provider providing an explanation, apology, refund, perhaps facilitating access to health records or implementing a policy change. It could also go to complex or formal resolution. So that involves a series of documented steps. It can take the form of a confidential conciliation meeting. We might request health records or reports or independent clinical opinions about the treatment provided. Again, some possible outcomes might be the provider providing an explanation, apology, refund, compensation, access to treatment, or implementing a policy change. I'd just like to stress that in resolutions, no determinations are made about the facts in resolution. It's really an opportunity to try and mutually resolve the complaint. And also at any stage in any of our processes, we can decide not to deal with a complaint. So we don't deal with every single complaint that comes into our office. And some of the reasons under the legislation that we can decide not to do that is that we don't think it warrants action. The complainant hasn't complied for a request of information when we've done so, or we don't think it should be investigated. So the Code of Conduct is set out in Schedule 2 of the Act, and it's part of the law in Victoria. It sets out the minimum legal standards for all general health service providers. It applies to individuals and bodies corporate, so in your personal capacity and potentially if you own a company that provides a general health service, it applies to the company as well. And when we're looking at that, we can investigate breaches or alleged breaches of the code and a failure to act consistently with the complaint handling standards. So this is a copy of the code. There's 17 code clauses that providers must comply with. Some of the most common code clauses that we see is the obligation to provide services in a safe and ethical manner, the obligation to obtain consent, the obligation not to misinform clients, the obligation not to engage in sexual misconduct, record keeping as well, and the obligation to be covered by professional indemnity insurance. So a copy of the code is available on our website as well. So in regards to investigations, the Commissioner can commence 3 types of investigations. The first one is what we call a Section 45 or complaint investigation. So that's when a person who has received or sought a health service comes to our office and makes a complaint about that health service that they've received or sought. People can also make complaints to our office on behalf of someone else. So, for example, a mother making a complaint on behalf of treatment her daughter perhaps received. We can also commence what's called a Section 47 or own motion investigation. So that's where the Commissioner can commence an investigation in her own name. Sometimes where that might be appropriate is where we've received intel from another organisation, such as Victorian Police or the Therapeutics Goods Association, or perhaps when we've received an anonymous tip-off, for example, that illegal cosmetic injectables are being provided in a certain premises. And the other type of investigation is a Section 46 or a minister-referred investigation. So that's when the Minister of Health asks the Commissioner to commence an investigation in relation to a specific provider. So when we conduct an investigation, some of the things that we might do during that process is obtain statements from complainants or other witnesses, obtain health records from either you as the provider or other providers that the complainant has gone to see, We will interview you or ask for a formal written response from you, and that usually occurs at multiple times throughout the investigation as well. We do have the power to execute search warrants. So that's where we can apply for a search warrant to the magistrate, and if granted, we can go into a premises and take the items that are listed on that warrant. Usually in those instances, it's usually in relation to illegal cosmetic injectables where we would use that power. We also might obtain independent clinical opinions about the treatment provided. We also look to other professional associations like yourselves and look at your code of conduct or your code of ethics to see so that we can determine what good looks like, what good practice looks like. We do have the power to conduct what we call investigations hearings, and that's where we can compel production of evidence and attendance at the hearing. We haven't used that power yet, but I'm sure that there will be a time in the future when that might be appropriate. And we also have the power to make interim prohibition orders or prohibition orders. And at the end of the investigation, we produce what's called an investigation report. And that will set out any findings of breaches of the code or the complaint handling standards and recommendations to address those findings. So in regards to findings and recommendations, so if we do make findings that someone has breached the code or the complaint handling standards, we make recommendations to address those findings. So some of those might be, they might look like completing further education in specific areas. And then once you've completed that further education, providing us with what we call a reflective practice report. And that's really reflecting on the complaint, reflecting on the education that you've undertook, and telling us how you're going to implement that education into your practice and comply with the code in the future. We might ask you to develop or implement a certain policy or procedure, for example, in relation to obtaining consent or record keeping. We can restrict the provision of a health service, so either restricting the provision of all general health services or a type of service, for example, massage therapy, or restrict practice for a certain period of time, for example, restricting practice while you're completing the education. For the last year, we've actually now got our own dedicated compliance team. So the compliance team monitor a provider's compliance with the interim prohibition order or prohibition order if it's made. And they'll also work with providers to help them comply with recommendations if they're made at the end of an investigation. And I also wanted to just point out that sometimes we make no findings and recommendations. So just because we've commenced an investigation doesn't necessarily mean that we will actually make any findings or recommendations. So that's also another option. In regards to some of the sanctions, so once an investigation is commenced, the Commissioner can make an interim prohibition order if she reasonably believes the provider has contravened the code and she's satisfied it is necessary to make the order to avoid a serious risk to the life, health, safety, or welfare of a person or the public. So the decision to make an interim prohibition order, it cannot be delegated, so only the Commissioner can make that decision. She can prohibit all or part of a general health service being provided. We must show cause. So what that means is the Commissioner cannot make an interim prohibition order unless she has sought submissions from the provider about whether or not that order should be made. IPOs last for a maximum period of 12 weeks. The Victorian Civil Administrative Tribunal has said that we can make more than one IPO during the course of an investigation. The IPO can also be revoked. So if new material comes to light that reduces the serious risk, then the Commissioner can revoke that order at any time. She can make an IPO against a person or a company or both. And it is an offence to contravene an IPO, which has financial penalties and also up to 2 years imprisonment. When an IPO is made, it must be personally served. on the provider and published on the HCC's website and in the Victorian Government Gazette. And any IPO that's made can be reviewed at VCAT. So the provider is able to make an application to VCAT for that to be reviewed. In regards to prohibition orders, so they occur at the conclusion of an investigation. And the commissioner can make that only if she's satisfied the provider has contravened the code and it's necessary to make the order to avoid a serious risk to the life, health, safety, or welfare of a person or the public. Again, this decision cannot be delegated, so only the commissioner can make it. Prohibition orders are very similar to interim prohibition orders. The main difference is that they are permanent. However, prohibition orders can be varied or revoked. So if a prohibition order is made, and again, there's been a material change in circumstance, a provider can come back to our office and to the commissioner and ask her to either vary or revoke it for whatever reasons. Again, it is an offence to contravene the prohibition order. And again, our provider can apply to VCAT for that order to be reviewed. The commissioner also has the power to make public statements. So there's two types of statements that she can make. One is a general health warning statement. So once the commissioner has commenced an investigation and she reasonably believes the provider has contravened the code and it's necessary to publish the order to avoid an imminent and serious risk. Or once she's completed her investigation, she can issue a public health warning statement to avoid a serious risk. Both of those statements, if made, need to be published in a local or Victorian newspaper and also on the HCC's website. I'd include a couple of case studies in relation to some investigations. So this provider provided laser therapy services. They were quite a large provider with lots of locations in Victoria. So the complainant alleged that she suffered second-degree burns following laser hair therapy to her arms, and those burns were confirmed by her GP as second-degree. So following the completion of the investigation, it was found that the provider had no contemporaneous record-keeping system. Consent discussions were not being recorded. There was no standard protocol questioning prior to clients receiving the treatment. Any adverse treatment outcomes were not discussed or recorded, and outcomes of treatment weren't recorded either. So ultimately, the commissioner found that the provider had breached Code Clause 1, which is the obligation to provide services in a safe and ethical manner, and Code Clause 15, which is the obligation to maintain accurate, legible, and up-to-date clinical records. What the commissioner did is she made the following recommendation, which was the provider must develop, implement, and provide evidence of record-keeping policies and procedures to our satisfaction. We outlined what those policies and procedures at a minimum should include, such as client record documentation, consent discussions, adverse treatment outcomes, and management of the outcomes. Evidence of those policies needed to be provided to our office within 1 month of the final investigation report being provided to the provider. And we also asked for evidence of how staff would be trained on those policies and procedures. So during the investigation, the provider engaged with us quite a lot, actually, and provided detailed responses. As they were quite a large organisation, they had their own internal medical advisory committee, and that committee reviewed the matter as well. We did give consideration as to whether the provider had breached Code Clause 2, which was the obligation to obtain consent, but ultimately that was not found. And also during this investigation, the provider made considerable improvements to their practice while we were also investigating the matter. So as a result, the provider updated their record-keeping policies. They developed and implemented procedures to manage adverse events including telehealth handover resources, escalation guidance documents, and came up with incident report forms. They also implemented a system that all records were now reviewed by the various clinic managers to ensure that they were up to standard. They provided training to all staff on record keeping, and they now make that mandatory for all staff to undertake. And their medical advisory committee delivered a national webinar to clinic owners and managers on the above, and that is now available for all staff as an online training model. So all in all, we think this was a good news story. And ultimately, at the end of the day, we want everyone to be compliant with the code and the complaint handling standards. And that's the ultimate goal. On the other end of the spectrum is we received a complaint that a general health service provider had engaged in sexual misconduct when providing massage therapy services. After we notified the provider that we were investigating the matter, and we sought submissions on whether or not to make an interim prohibition order, we did make an interim prohibition order prohibiting the provision of all general health services. Given this matter related to a criminal offence, we notified, with the complainant's consent, we notified Victoria Police. Once Victoria Police became involved, we put our investigation on hold pending the criminal proceedings, and this person has been charged with rape and other sexual offences. So this is also taken from our website. So this is our annual report for the last financial year. So I thought it would be good to include it just to give you a bit of an overview about the complaints that we received in the office. So overall last year, we received just over 6,000 complaints and nearly 3,000 inquiries. Of that, nearly 6,000 of those were complaints made under the Health Complaints Act, and around about 200 were made under the Health Records Act. Of those complaints, most of them came through either via phone call or via our online web form. And a small amount we received by email or in writing or in person. In regards to the complaints, nearly 3,000 of those were dealt with within 30 days of receipt by our office, and about 4,500 were dealt with within 90 days. In regards to investigations, we commenced 33 investigations and we closed 40. Of those investigations, 20 were complaint investigations and 13 were own motion investigations. We issued 82 orders, so that includes interim prohibition orders and prohibition orders. Issued 2 public statements, and we also revoked 2 orders. So who were the complaints about? So 292 of those complaints were about general health service providers. So you can see that in the grand scheme of things, that's actually quite a small number. 1,434 complaints were about hospitals. So that's both private and public. 922 were about prison services. Nearly 1,500 were about registered health practitioners. And nearly 1,500 fit into the other range, which, for example, is like pharmacies or day procedure centres. So what were the complaints about? So some of the common issues in relation to general health service providers that were being raised was the obligation to provide services in a safe and ethical manner, complaint management, and financial exploitation. Some of the other main issues were in relation to consent, sexual misconduct, record keeping, or the obligation to have insurance. In relation to non-general health service providers under the Health Complaints Act, the main issues were in relation to treatment, access to treatment, and medication. And in regards to the Health Records Act complaints, The main issues were in relation to access to records, use and disclosure of records, and data quality. So Erin has posed some questions to me, which I will endeavour to answer now. So the HCC is a Victorian organisation. Are there equivalent bodies in other states? Yes, there is. There's one in every state and territory in Australia. However, some of our powers differ. So, and some are, for example, in New South Wales and Queensland, it's a co-regulatory scheme as well. I thought I would just put in here that when we do make an interim prohibition order or prohibition order, we do have an obligation under the Act to inform our interstate counterparts. And Section 102 of our Act states that if you're prohibited in another state or territory, then you're automatically prohibited in Victoria. What should I do if a complaint is made about me? So I would suggest that you talk to your assigned resolutions officer or investigator about the next steps, and if it's appropriate, how you can resolve your complaint. It's really important you can contact your indemnity insurance provider and they can provide you with legal advice. And if you do find yourself that you're engaged with the investigations team, I would strongly suggest that you do that because it can be really helpful for both parties. If it's appropriate to do so, engage in the process. And some other tips here is it's always really good to keep comprehensive and contemporaneous health records. It really helps us understand what's happened and what you've done as well. And also, this is a tip from our one of our resolutions managers is to keep records about what you've already done to address the complaint. So if the complainant has come to you and has tried to resolve it with you, make sure you keep, detailed notes about what's happened, when, and what you've done to try and do that. If I have a complaint made about me, do I have the right of reply? Yes. If we decide to deal with the complaint, then yes, you will definitely have a right of reply. So in resolutions, engage with the resolutions officer and try and resolve the complaint if it's appropriate. In investigations, before any decisions are made, such as the making of an interim prohibition order, or before we finalise the report, you always have an opportunity to respond and provide any information that you want the HCC to consider. What steps can I do? Can I take to avoid making a complaint? To avoid a complaint being made against me? This is a bit of a tricky one. Because clients do have the right to complain, and sometimes you can't stop that. They will do that. But I just thought complaints aren't always a bad thing. It's really an opportunity for you to reflect on your own practice and processes, and perhaps implement some things to improve them. Other tips: comply with the code and the complaint handling standards. And the other thing is ensure that you have your own robust complaint handling policy or procedure in your workplace. And I've just put communicate clearly with your clients. Often we see in the investigation space, perhaps a person, alleges that that the provider's engaged in sexual misconduct. But when we actually look into what happened, it really comes down to informed consent, and communication wasn't clear, and the complainant misunderstood what was happening. So ensure your informed consent is obtained, and ensure that that's dynamic throughout the treatment process. If a complaint is made against me, is that put on public record? So the HCC will keep a record of any complaint or information received. In certain instances, we may need to notify AHPRA of that complaint, as I spoke about earlier. If the complaint does pose a serious risk to the public, we may need to disclose those details to other agencies, such as Victoria Police. A complaint made to our office is not necessarily a criminal offence, and it won't show up on any police check or working with children check. But if it does amount to a criminal offence, then there's an ongoing police investigation and potentially the person's been charged or convicted, then that obviously will show up on those checks. And as I've said before, IPOs and POs and public statements, we have an obligation to publish them, so they will be publicly available. And just at the end, I just wanted to clarify that not all investigations result in an IPO or a PO or public statement made. It's actually quite a relatively small portion of what we deal with in investigations. I've just included some resources here. So as I said, the Code of Conduct and the Complaints Handling Stand, they're on our website. We also offer a range of training and seminars in relation to complaint handling, the code, or the Health Records Act, and links to any orders or public statements are also there. Thank you.
Oh, that's wonderful. Thank you, Imogen. I really enjoyed that. That was incredibly informative. And I think, yeah, talking through some of those questions at the end there is really valuable for our members, because at the end of the day, as you pointed out, whilst lots of complaints can come into the HCC, only a small portion of them are about the types of services that Myotherapist provide, and then only another small portion, again, as you said, end in orders being made. So that's really interesting. So thank you. So thank you so much for your time today. Thank you for being part of our Myotherapy ConneX webinar series. And I really know that our members will have found that very helpful and reassuring. So as we sort of said at the start, complaints can be incredibly stressful, but being informed about this process, understanding the codes, understanding our responsibilities, a lot of that stress can really be relieved. So thank you so much for that valuable information.
Thank you for having me.
So thank you everyone for tuning in today. We always love sharing practical information to help you expand your practice and knowledge as a myotherapist. Don't forget to visit our online PD platform for more amazing content and professional development opportunities. We'll check in next time on Myotherapy ConneX from Myotherapy Australia.